It's the voice of Indiana County. It's WCCS 101.1 FM, AM 1160, WCCSradio.com. Our conversation next with Marshall Chriswell. We call it Martial Law. And this program intended for informational purposes only. The information does not constitute legal advice. The law is constantly changing. The information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of these differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. A guy, for instance, like Marshall Chriswell, who is on the line with us this morning. Good morning.
Good morning.
Happy Monday to you. Let's talk a little bit about something that comes up a lot on this segment, and that is estate law and making sure that everything is the way that you want it to be in dealing with your estate and your wishes for when you are no longer here. And one of those issues is the executor of your estate. We might start by telling what an executor is and why we might appoint someone to be our executor. But I also want to get into why we might remove somebody as an executor. So let's start first with what an executor really is.
Sure. An executor is the personal representative of an estate, and so they are the person who is authorized by the court after someone passes away to they are legally authorized to handle that person's final affairs, whether it be selling assets, complying with the legal requirements of an estate, paying off debts, taxes, doing all these things, and ultimately making distributions to the beneficiaries pursuant to the person's will, or if they didn't have a will, pursuant to relevant Pennsylvania law.
Well, when you do that, you're wanting to name the person that you think would be best able to do that and that you can trust with all of those duties, but there might come a time when you say, that's probably not the person I want to be my executor. So what are some of the reasons somebody might remove someone as an executor, and how easy is that?
Sure. So what we're talking about is after a person passes away, and their executor, the person they've named in their will to be the executor, or if they don't have a will, or if the people they've named in their will are no longer alive or able to do that, there's going to be someone appointed to have this legal responsibility to manage the estate. And once the person passes away and the estate is formally opened with the court, this person will be appointed, and they're given what's called a grant of letters, and that's what the document that's under seal from the court that says, yes, this person is the legal representative of the estate, and that carries with it all the rights and responsibilities of managing the estate. And there are lots of times when that person, wittingly or unwittingly, doesn't do their job properly, and there arises grounds for their removal.
Mm-hmm. I would assume that there are times when somebody says, I can't do the job, and they want to be removed, but that's for another time. Let's continue on this particular topic. So if you decide that person is not really the person for the job, and you want to remove them as the executor of your estate, what must you go through? What's that process like?
So you have to either get the consent of the person, and there can be benign reasons for someone needing to be removed. They've gotten ill, they've become incapacitated, they have other life responsibilities in their own lives that they say, well, I just can't handle this anymore, because it is kind of a job. I mean, it can be a lot of responsibility to be an executor or an administrator of an estate. And so there can be benign reasons where the executor might say, okay, yeah, I'll sign a consent and we'll let the court appoint someone else. But there certainly are situations where the executor does something where they have harmed the estate, or they have given rise, like I said, to actual grounds for removal. And I was in thinking about this, I came up with at least a partial list of what these reasons could be, where somebody has engaged in self-dealing. They have taken assets from the estate for themselves, or they've sold themselves assets at a lower than fair market value price, or to other family members or friends, and they've sort of gone behind the backs of the beneficiaries to do that. Just plain inaction. That might be the most popular reason that somebody might want to remove an executor from their post, is that they just haven't done anything, and for no good reason. We've talked about in this segment the fact that estates can take a while to settle, and there are good reasons sometimes that things are delayed, but there are also situations where someone takes on the responsibility of being an executor, and then they just don't do anything for no good reason. And what got me thinking about this actual segment today was reading a Superior Court case, the state appellate court case that just came down recently, where an executor was removed because he didn't do anything for 25 years.
Oh my!
He was appointed executor back, in the late 90s, and basically there was a piece of real estate was the one asset of the estate, and he just sat on it for 25 years, and he rented it out, and he kept the income, and he paid the expenses for the property as well, but he just didn't do anything and never made any attempt to distribute any of the income or to sell the property or do anything. And finally, one of his sisters got fed up and filed an action in the county orphans court, and the judge agreed for him to be removed, and he appealed it to the state superior court, and they affirmed it because it was a clear-cut case, right? He just hadn't done anything for 25 years. Yeah,
well, and that brings up an interesting point where we might think that removing someone as an executor is something that someone who has set up the estate says that they want to do. Before they pass away, they want to change the executor. But this is a case where the person passed away and someone was in charge of being the executor of the estate, and those who would be the beneficiaries, the family, most of all, said, "This isn't working out. Let's find a way to get rid of them."
Yeah, and that's most often the way these things come up, right? Is the beneficiaries of the estate realize or perceive or think that there is some misconduct, or in this case, total lack of activity by the executor. And I get these types of calls all the time. And like I said, I came up with a list of things that you might want to remove an executor for. And I might have 8 or 9 things here on my list. None of those things on my list is just because you don't like the person. Okay, just because we don't get along, or I think they didn't treat mom or dad well when they were alive, or these kinds of things, and a lot of times that's what it is, and those aren't legal reasons, of course, to remove an executor from their duties, but those are certainly sometimes things that give a spark to a dispute that can later result in the removal because of the additional scrutiny that's put on the executor by their family members that despise them. And so, and just, if an executor is part of their responsibility, it's not just the financial part of it to make sure that the accounting is right and that we make sure to sell things in a timely manner and do all this. There's also a part of it, part of their responsibilities is communicating with the beneficiaries, keeping them reasonably updated, and cooperating with them to a necessary degree to carry out the wishes of the decedent, the person who passed away. So all of this kind of goes to, you want to make sure you're picking the right person.
Yeah. That being the case, sometimes when an executor is removed, then the family is going to want to appoint somebody new, and they might not always agree, and that might extend this rather troublesome situation even further. Is there ever a time when a judge will step in and say, all right, you obviously are never going to come to a solution here, so let me appoint the executor?
Absolutely, and that's what happens if you are petitioning to remove an executor. Then, by the very nature of that action, the court is now involved, and so the court has to make obviously a decision about whether the evidence that's put on at a hearing warrants the removal of the executor, and whether the executor needs to now file a full accounting, and all that. There are things that the judge has to decide. But the other side of that, you're right, coming out the back end of that is, hey, who is going to steer the ship moving forward? And is it the person who filed the petition, and they want to be appointed executive? Is that the right person, or is there another family member or someone else? But in some situations, and I have a couple of these types of matters here in my office, where a judge says, "No, I'm not going to. These people can't get along. They can't, and none of them really seem competent to do this. So we're going to appoint a professional." And often they'll appoint an attorney, maybe a local member of the bar. So I have several estates where I'm serving as executor because the court said no. The family just isn't going to be able to get this done, isn't going to be able to get this across the finish line. So we're going to appoint a professional to do it.
Wow, there you go. So that's a very complicated issue, well explained by you. Marshall, if somebody wants to get in touch with you and line you up to help them through this whole process, what should they do?
You can call me at 724-465-5826. Stop and see us here in the old RMP Coal headquarters at 655 Church Street in Indiana, or go online to the website at www.westernpalawyer.com.
Marshall, thank you.
Thanks, Todd. Take care. Have a good week.
You too.